With a large number of people renting homes in Ontario, there will sometimes be problems between a landlord and tenant. The Landlord and Tenant Board can give you information about your rights and responsibilities to help you solve these problems on your own. If you can't solve the problems on your own, you can file an application with the board. The board can make a decision about many landlord and tenant matters under the Residential Tenancies Act. This is the law that deals with most residential rental tenancies. If you have a problem in your tenancy, you should first talk to the other person. If you are a tenant, talk to your landlord. If you are a landlord, talk to your tenant. You may also want to put your concerns in writing. If you're not sure what the law says, get information from the board. The board has information about your rights and responsibilities as a landlord or tenant. To find this information, you can visit the board's website. It has lots of information and all the board's forms. Call the board's call center. You can listen to pre-recorded information 24/7 or speak with a customer service officer during regular business hours. Visit one of our 8 offices throughout Ontario to speak to a customer service officer. If you still can't solve the problem, you can find out from the Landlord and Tenant Board if you can file an application to get the problem solved. It is important to use the right application for your tenancy problem. If you're not sure which application to use, check with the Landlord and Tenant Board. It is also important that you read the instructions to the application and complete your application properly. Once your application is filed with the board, a hearing is scheduled. A board mediator can help you and the other person talk about your tenancy problems and come up with your own solutions. If you can solve your problems through mediation, your hearing is canceled. If you can't solve your problems, then the hearing will go ahead as scheduled, time permitting. Mediation is voluntary, so if you and the other person don't agree to mediation, you must both go to the hearing. It is important that you both go. If one person doesn't go, the board member will usually proceed to hear the application and make a decision without that person. For most hearings, the landlord and tenant appear in person in a hearing room before a board member. However, sometimes the board uses written hearings or telephone hearings to decide an application. At the hearing, a board member considers the evidence that the landlord and tenant present. This can include oral evidence, documents, pictures, and agreements such as leases. The member will make a decision on the application based on the evidence and what the law says. A board member is similar to a judge in the courts. A member's final decision on the application is a written order. A copy of the order is sent to both the landlord and tenant. Orders are the law, and you must follow what they say. If you are a landlord or tenant with a tenancy problem, and you want to know how you might solve it, get information from the board. Talk to the other person and try and solve the problem together. If you can't solve the problem, file an application with the board. You can try mediation and let a board mediator help you and the other person come up with your own solution, or go to a hearing where a member will make a decision about the application.